Just go on the next lesson.
Hello, Richard.
Hello, Anastasia. How are you?
Thank you. Fine. And you?
Not bad. I've had a lot of visits to the dentist this week. Oh my goodness! But I finally, on the last one, I had to go back again, yet again today. But now they've finally done everything.
Oh,
So,
I'm happy.
yeah, me too. I'm in Macedonia still. I'll leave for Turkey on Monday. No, I'll leave for Turkey on Saturday. And then I'll leave for Oman on Monday. That's it. Let's let Maria in.
You have so many business trips?
Well, I don't know. Normally not, but it's just. See, the problem is, like yourselves, I normally live in Kiev, so I can't go home at the moment. I can't go home while the internet switches on and off. I can't run my business unless I've got smooth running internet. Now, I don't want to take a long-term lease of an apartment somewhere because it's possible in February, March, it'd be safe to go back to Kiev. But on the other hand, you can only visit a country as a visitor with a visitor's visa for 90 days. So I'm moving from country to country. Now, I'll probably spend the winter in Izmir in Turkey. It's okay. Good internet, easy to fly from Istanbul to customers or training in the Middle East, which is the main center of my business. But I can't fly. I was in Albania. It's very difficult to fly from Albania to Izmir. So I had to travel from the south of Albania up to Tirana. Then after a couple of days in Tirana, fly to Macedonia to see friends and also some business I have. And I'll fly to, I've got training in Oman next week. Tuesday, Wednesday, Thursday.
Oh.
So that's why I've got to go to Izmir, then the next day, 2 days later, fly off to Oman. And then a few days later, fly back to Izmir and then stay in one place till the end of January or February when I'll come to the UK for a while.
You're very busy.
It is tiring. I used to like travel a lot. I don't like it so much now. It's been 9 months since I was in. 9 months since I was at home. I hate it, living out of a suitcase. Well, all of us hate it. I know. On the other hand, I speak to people in Kiev today, they've been without power for God knows how many hours. They've gone to bed early because it's cold. So it's bad of me to complain. My business is to take my mind off things. I concentrate on my business, as a result of which, of course, it's grown dramatically in the last 12 months. So I shouldn't complain. Let me let Vika and Akea and Christina.
Hi, Richard. How are you?
Hi, I'm fine, thank you, Olga. I'm fine. Hi, how are you?
Hi, I'm good, thank you. Nice to see you.
Thank you very much.
Hi.
I was just explaining, I've had a lot of dental work done in Macedonia. I'm in Macedonia. One of the reasons I'm here is we're setting up, or I might be involved in the setting up of a medical tourism business, a clinic, or wellness center spa, various other things outside the main city in the mountains. And I'm just here to see how things are going with that project. But while I was here, because dental work here is as cheap as dental work in Ukraine, I had a lot of work done on my teeth, which needed some work. So the final root canal treatment was this afternoon. I didn't like that very much. I thought I'd be brave and not have an anesthetic. That was a mistake. There we go. But it's done now. Right.
But are you feeling, Richard, are you feeling well right now? Is it okay for you to proceed with it?
Of course,
really?
This is my second lesson this evening. I've just finished broadcasting to Brazil. So, you know, I'm happy to speak to
Brazil?
you. Oh, yeah. We have some, this is a global business. So we've got a new center being set up in Sao Paulo. Sao Paulo, you see, there are very few cities of the world where I can set up a center. They've got to be cities of at least 20 million people to have enough potential students. Sao Paulo has about 25 million people living there. It's like Istanbul or Greater Cairo. Istanbul's got about 25 million people. Greater Cairo has possibly got 40 million. So these are places where I can have our training centers. So the Brazil center is for the whole of South America. Cairo is just for Egypt. And we're looking at a center. I've got to go to Oman to talk to my Saudi partners who are flying over about setting up a center in Saudi Arabia. I like this, of course, but I'm just getting a bit tired of all the traveling.
You need a good assistant.
Well, I do, but I mean, could you, I mean, I do, I know. Thing is, unfortunately, I'm a micromanager. If I hadn't, well, when I have assistants, I overlook everything they do. I may as well have done it myself. Well, there we go. However, you know, it's good.
But you very like your work, yeah?
Very much. I wish I was a litigation lawyer and I had a law company, etc. Fine. But I much prefer teaching. One of the fingers crossed, first of all, everybody taking this course, we're going to give you a certificate, and this certificate will include 15 hours of CPD points. So you can mention this in your CVs. Continuing professional development. Employers like to see it because it shows your commitment to constantly improving your professional ability. However, the real big news is that provided everything goes okay, all our courses will in fact be incorporated into the law courses of a university in the UK, which is a very senior member of the Erasmus scheme, which means every course you take with us will carry points towards an LLM or an LLB or an MBA across all European Union universities. That's a very big deal. I want that in place before we set up the center in Saudi Arabia. And I'm waiting for my English partner to actually get on with it. Unfortunately, he has family problems and he's taking his eye off the ball, as we say. He's not in the same, doesn't have the same sense of urgency that I do. Well.
Yes,
okay.
Richard, it's really a great news. Thank you so much for your support. Really, indeed.
Well, you know,
we will get the certificate. Yeah, thank you.
Oh, yeah. I just feel, you know, I've lived in Ukraine for 18 years. I've lived in Kiev for 18 years. It's never lived in any one city in the world for as long as I've lived in Ukraine. Unfortunately, my Ukrainian is very, very bad. As you can probably guess, I speak Russian, but not Ukrainian, so I'll do something about that. But I can't wait to go home. I want to be at O'Brien's Irish pub, watching the rugby with the other expats. I mean, I want to get down to the Lviv chocolate shop. I want to be back in Kiev, where I feel comfortable. There we go. I know you like it in England. I don't. I like being a foreigner. I like being away from my country.
Why
Anyway.
you don't like being in England?
What I don't like in England, of course, well,
Yeah.
I liked it when I was growing up. I just don't like the way it's changed. It's a lot of administrators. Ronald Reagan once said, the most frightening words of the English language are, I'm from the government and I'm here to help. That's exactly how I feel about the UK at the moment. Everything is micromanaged by the politicians who've let down the public, by all these administrators working in local government, by the, I hate these people. I'm much happier in a place like Macedonia. Do what you like, get on with it. Nobody's going to bother you. The place, of course, is run by the mafia. Absolutely no doubt about who's in charge here. The mafia are in charge. But because of that, there's no trouble. Because everybody's too scared to do anything bad. Because you have to answer to either the Kosovo mafia or the Albanian mafia or the Macedonian mafia. We're sourcing the protective vests for the soldiers in Ukraine. And who do you think has all this military equipment? The mafia. So we have to deal with them. But there was one thing. They do what they say they will do. They're not like a politician who kind of promise and then not do anything.
Yeah.
Interesting place. It's an interesting place. Right, now then, let's get on with our lesson, okay? Thank you. We got 26, right? Thank you for joining me, everybody. As you can probably guess, I'm recording all this, so I'll be sending the recording to everyone later today or tomorrow morning. Alina, Irina, Vika, Olga, Dennis, Christina, Maria, and Natalia. Natalia, thank you very much for joining at such short notice. Yulia, thanks everybody. Now, we're going to look at employment law. Actually, we're going to look at contract law. But I want to finish off our little discussion about employment, because I know you'll be going for interviews or hoping to get interviews. I want to deal with the sort of vocabulary, legal vocabulary, you'll have to deal with in the interviews. So what I'm going to do is I'm going to share my screen, and then I'm going to bring up a text from the, not from the main textbook, which I've sent everybody, but from another textbook relating to vocabulary used during interviews, legal vocabulary relating to employment contracts. Let's just check here. Right. Right, let's bring this up. Where are we? The Lawyer's English Language Textbook. Right, let's just increase the size of this. Right. Let's leave that exercise for a moment. Let me just move this out of the way so I can. Where are we? Let's pull this down here. Right. Well, first of all, I want to deal with some prepositions. Okay. We're going to look at some legal adverts, and then I'm going to ask you to read and understand them and answer questions, yes and no, about their contents. And then we're going to look at the vocabulary, legal vocabulary relating to employment contracts. Right, but first of all, though, here are, in exercise 4, we've got 5 sentences with blank space in each sentence. One of the great problems for non-native English speakers and for native English speakers is dealing with legal prepositions. As you know from your general English language study, there are no rules as to why, even in conversational English, it's paid in rather than paid to or paid at. What we've got here are conversational English sentences, and I want you to tell me which preposition goes in each box. For example, I heard something, Stephen Brown yesterday, he sent me a postcard. He's working in Sydney for a year. So I heard what? What preposition goes in there? In, on, at, to, from, with, under, against, of? What preposition goes in sentence A? Just write in the chat box for me. Now, I've got how many? 25 of you. So, that's good. I want at least 10 answers. That's great. 12, 13. Let's see what you got. Excellent, everybody. Yeah, from. I heard from. You hear about a job, but I heard from Stephen Brown. Good, everybody. Right. Now, this is how you tell an employer what your telephone number is. You can contact me, what? Chatsworth 577-9940. That's great. You can contact me, well, okay, at yeah. Or via Irina, that would be good as well, but at is better. You could actually, you can contact me on Chatsworth 577. You can contact me at Chatsworth 577. You can contact me via Chatsworth 577. That's good. Now, let's say you went for a job which involved dealing with employment law. The employer might ask you, do you have an up-to-date knowledge? What? Disciplinary and grievance. Grievance means complaint. Grief, sadness, right? Grievance means you've got something to complain about. I've got a grievance. Yeah. You have up-to-date knowledge, what? Disciplinary and grievance procedures. Julia, I think you're correct, you know. I think it could be both on and in. Actually, I beg your pardon. Sorry, everybody. My well, on or in is what most people would say. In fact, it's not. It's of. I know on or in is the colloquial way of speaking. Do you have up-to-date knowledge on discipline? No. Do you have up-to-date knowledge of disciplinary and grievance procedures? Do you have a working knowledge of employment law? Of, not on employment law or in employment, of discipline. This is why prepositions are so difficult. There's no logical reason as to why it's of rather than in or on. It just happens to be of. Now, what's the next one? This is there's lots of, well, okay. There's a formal and an informal way of answering this. Do you have any experience of dealing with people, something the telephone? Excellent, Natalia. Excellent. Not over the telephone or by the telephone, but on the telephone. Okay. Good, Olga. Good, two of you. Good. Do you have any experience of dealing with people on the telephone? Not by the telephone or via the telephone or through the telephone, but on the telephone. We deal with people on the telephone. I've no idea why we'd say they're on the telephone. They're holding the telephone rather than standing on it, but it's on the telephone. Okay. And E, my contract of employment says I have to deal with any task relevant to my job. Oh, very difficult. This is a very idiomatic phrase. But to deal with any task relevant to my job, something required, meaning when I'm required to do it, I must do whatever they tell me to do, whatever I am required to do. A requirement is something, it's like a need. We instruct you to do it. It's your instructions, your orders. You're required to do it. Now, that's a very difficult one. I'm going to give you a minute or so, or half a minute, see if anybody else can answer. Now, don't be afraid about making a mistake, okay? So what? You make a mistake. What's the worst that could happen? So what? It's much more interesting when you all, even if you don't know, have a guess. All right, 6 of you. Okay, I said it was difficult. I'm just going to let the other people in. Oh, they're in. Okay. Okay. Right. My contract of employment says I have to deal with any task relevant to my job. Oh, very good, Anna. Very good. As required. Anastasia. Olga. Okay. Now, Natalia, you could put if required there, but it's not. But it's it's as required. Okay. Grammatically, you could put if required there, but it's not the same. It's a contract of employment, so you must do all the tasks as required by your employer. As required. Okay. All right. Now, whilst we're talking about this sort of vocabulary, these are sort of things that you'll hear. First of all, your past jobs are your previous experience, earlier experience or previous experience in the past. We apply for a job. We generate new business. If you do join a law firm, one of the things they'd love to hear is that you're going to bring in new clients, which they would consider to be generating new business. And if you work with a particular department, then you join a department. And of course, they say, can you forward your CV to me? They don't say, can you send your CV? They'll say, can you forward it to me? It's a slightly more formal legalese way of saying send. Okay. Now, as I said, prepositions are difficult. So I've got here some. A track record means you've worked in it in the past. You have experience. So we call it a track record, like the record of your sporting achievements. To have a track record in a particular area, have a track record in mergers and acquisitions work. She has a strong track record in financial sales. Right. Now, to be confident of. You need confidence, of course, and in the sense that you believe you'll be successful. That's what they want to hear. Because you've been successful in the past. So you are confident of something. For example, I'm confident of my ability to increase sales. Or I'm confident in my ability to increase sales. Both are correct. And also we work in a company. And having worked in a company, we work within a section or a department of it. So I work in sales, I work in Marks and Spencer's, and I work within the sales and marketing team. So we work in a company and we work within a section of that company. Now, this is a phrase meaning, do you know it? Do you have experience of it? Are you used to dealing with it? To be familiar with something. Okay, familiar is an interesting phrase. We can say that somebody is impertinent in that he's very familiar, meaning he was too informal, as if he was my friend, even though I hardly know him. He's very familiar. Are you familiar? But on the other hand, we also mean to know something. He's treating me like he knows me. But if I talk about your legal knowledge, I might say, are you familiar with recent employment legislation? In other words, do you know the recent cases? Are you familiar with the ways in which mergers and acquisitions can be conducted? Are you familiar with the English legal system? Yeah. Do you know it? We have experience of. I've had 5 years experience of working as a receptionist. All of you had years of experience of working as lawyers in your home country. And then we focus on or focus upon something. They're interchangeable. They're very much synonyms here. In this company, we have a strong focus upon client satisfaction. Probably sounds even better to an English person to say, in this company, we have a strong focus on client satisfaction. Right. So those are some vocabulary. There's some preposition. Right. Now then. I want to deal with this vocabulary, and then we're going to complete the exercise by putting these 12 words in the correct place in the text. Employers, well, you know what they are. They're the people or the companies, the entities that employ people. Confidential means keeping things secret. Representation, well, lawyers represent clients. So representation is the noun for the process of acting on behalf of a client. Data, well, that means something from the computer, information. Judgments, you know what that is. What comes from a court. Complying means doing what the law says, or what the judgment says, or what somebody tells you. Statutory means from statute, legislation. Safety means keeping safe. Tribunal, as you probably know, is an important part of the UK judicial system, in that there are various tribunals run by professionals working within a particular industry, which have some of the same powers as a court. An employment tribunal will have a lawyer as the chairman, a union representative as one of the panel, and an employer as the third member of the panel. A mental health tribunal will have a lawyer as the chairman and a doctor or 2 doctors as the other members of the tribunal. Governed. Governed means controlled by. Well, you know what government is, so governed. Legislation is written, acts of law coming from the chief, the head legislative, the senior government body. In the US, it's Congress. In Ukraine, it's the Rada. In Britain, it's the Parliament. They write laws, and this written law is called legislation. And paternity means fatherhood, pater, Latin word for father, pater. Paternity means fatherhood. Right, now then, I think you're sick of hearing my voice. I'd like a couple of volunteers to read to us out loud so I can hear your pronunciations. Who'd like to volunteer? Anybody want to put their hand up?
Okay, I can.
Well, whoever that is, you go ahead. I want you to read the first paragraph. In fact, the first 2 paragraphs down to the 9th line. Okay, please go ahead.
It is extremely difficult to describe a typical case in employment law because there is a lot of variety. For example, the nature of the work means that you have to deal with contentious work, such as acting for a client at an employment. And non-contentious work, such as drafting a contract of employment. I decided to specialize in employment law because the work is varied and interesting.
Okay, thank you, Anastasia. Now, a couple of things. Lisa, I'm going to ask you to read something in a moment, but before I do, first, you may have heard me say this before, and I want to say it again. Never be afraid to speak slowly in English. Top politicians, people who make speeches that other people have to listen to, all speak slowly. You listen to Winston Churchill's speeches, very slow. You listen to Barack Obama's speeches, speak slowly. Forces the listener to concentrate on what you are saying. Right, next. So when you're reading English, don't be afraid to speak slowly. And one way in which we speak slowly is we pause very slightly after each comma and a slightly longer pause after each full stop. Right. Now, let me go through a few words which cause, I just want to get the pronunciation right here, okay? I'll read this again. It is extremely difficult to describe a typical case. Sorry, I saw my internet is broken. I have a stronger internet on my phone. If we get cut off, I'll switch on to the mobile hotspot on my phone. Okay. Because there's a lot of variety. Anastasia, just say the word variety for me, please.
Variety.
Good. The nature of the work means you have to deal with a lot of contentious work. Let me see, somebody else. Not you, Anastasia, but somebody else. Just say the word contentious for me. Anybody? Lisa, would you like to say it?
Contentious.
Contentious. Contentious, great. Contentious, contend means to argue. Lawyers say, good, I would contend that my client is not guilty because it is my contention, meaning my argument, it is my contention that the court should adjourn this case until the witness can attend. The two boxes are contenders. Okay, contend. Contend with a d at the end means to argue. To be happy in your life is to be content with a t, not a d. There's a big difference. A very tiny change in pronunciation, but a big difference. So we have content and contend. Lawyers are rarely content because they have to contend in court so much. Okay. Who'd like to say content, contend for me? Anybody?
Content, contended.
Make the second word with a d. Even we put the tongue touches the top of the mouth behind the front teeth. Duck, like a duck. There's a duck in the water. Okay, just say there's a duck in the water for me.
Duck in the water.
Good. Now say contend.
Contend.
Again, please.
Contend.
Excellent, Anastasia. Excellent. Just say once more for me.
Contend.
Great, great work.
Thank you.
Now, if I'm happy, I'm content. Would somebody just like to say content? Are you content in your work? Anybody? Somebody else?
Content.
Right. Great. Say it again for me.
Content.
Excellent. Excellent. Okay, right. So you have to deal with non-contentious work, such as acting for a client at an employment what? Which of these 12 words fits in this blank space A? At an employment?
Tribunal.
Representation.
Okay, write it in the chat box for me, please, ladies and gentlemen. one of you. Now, come on, there's nearly 30 of you. I want more than one answer, okay? As I often say, you know, rather foolishly, what's the worst that could happen? I mean, who cares if... Just 5 of you brave enough to give me an answer. 7, that's better. When you're Ukrainian, the rest of the world thinks you have absolutely zero fear. So answer my questions, okay? Right, let's have a look what we got here. Representation, tribunal, confidential, tribunal, confidential. Okay, at an employment tribunal, an employment court, an employment hearing, a tribunal. Okay, so you have to deal with contentious work, such as acting for a client at an employment tribunal, and non-contentious work, which means no arguments. And non-contentious work, such as drafting a contract of employment. I decided to specialize in employment law because the work is varied and interesting. Varied. Unfortunately, while it's varied, the noun from that process has a different pronunciation. That is variety. Varied and variety. You can see the big difference in pronunciation. Okay. Right. Who would like to read now? Lisa, are you going to read the next paragraph for us?
Yes, but please move. Thank you.
Okay, there we go.
Cases are usually of a very sensitive nature and are therefore highly confidential, sometimes requiring very careful handling. I act for both employers and employees, although to be honest, it is usually an employer who is more likely to be able to afford legal.
Don't tell us what it is. Legal something. Okay, good. Okay.
Okay.
Right. Please go on.
However, it is an area of law, perhaps second only to family law, where a client's emotions are involved. To work in employment law, you need to be able to cope with that and to understand that clients feel very strongly about the issues concerned. Very
good. So, B, therefore highly confidential because they're sensitive. Now, what's the answer to C? I want you all to write in the chat box for me. It is usually an employer who is more likely to be able to afford legal what? Legal what? Okay. Good, Natalia. Good, Irina, Alina, Olga, Anastasia, everybody, Lisa, everybody. Representation. Because the employers have got more law, they can afford more money, they can afford a lawyer. So we gain legal representation. To gain legal representation, I mean, have a lawyer speak for you. However, to work in employment law, you need to be able to cope with that. Cope means to deal with, to manage, to be able to perform properly, to cope with difficulties, to cope with the amount of work, to cope with stress. Meaning we can deal with it. Doesn't bother us, we can cope with it. Good. Right, now who'd like to read? Now I don't want you to tell me the answers. Who'd like to read the next paragraph? Anybody want to put their hand up? Anybody?
Can I?
Sure, Alina, go ahead. Go ahead, Alina, that's great.
Employment law covers the rights of workers and the obligations of.
Don't tell us what it is, okay? Obligations of something. Good.
In the UK, these rights are obligations come from the following main sources. Act of Parliament, which give rise to rights and obligations. Employment contracts, which give rise to contractual rights and obligations. This area is largely by the common law, and there is a large body of law created by earlier decisions, European Union legislation, and from the European Court of Justice.
Good. Good. Good pronunciation. Nice, clear speech. Very good. Okay, let's have a look at this then, okay? Employment law covers the rights. That's an old Anglo-Saxon word. The Norman French word is entitlement. Anglo-Saxon word says my right. It covers the rights of workers and obligations of who? Obligations of who?
Employers.
The rights of, yeah, put it in the chat box for me, okay?
Sorry.
Otherwise, the others don't have to do anything. Great. Employers, everybody's got it. Well done, everybody. Well done, everyone. In the UK, these rights and obligations come from the following main sources. First, Acts of Parliament, which give rise to something rights and obligations. Acts of Parliament, which give rise to something. What was that again? Give rise to, yeah, okay. Give rise to something rights. Give rise to. Okay, not easy this time, okay? There are the words. Let me just have a look at this question again. They give rise to something rights and obligations. Oh, I see what it is, yeah. What type of rights are they? The rights given by the law, written law. So what type of rights are they? They are, we call the written law, like in any civil code, we call it good, Olga, Anna, Yulia, Alina, Lisa, Elena, Vika. Very good. Statutory rights. Rights you are given by statute. You have a right not to be dismissed unfairly by your employer. It's written in the Acts of Parliament, so it's a statutory right. They give rise to statutory rights. Employment contracts, which give rise to contractual rights and obligations. This area of law is largely something by the common law, and there's a large body of law. This area of law is largely what by the common law? Governed by. Very good. It's governed by. Everybody's got it. That's great. Governed by the common law. And something from the European Court of Justice. What do you think that would be from the European Court of Justice? What does a court issue? Judgments. Oh, great stuff. Well done, everybody. Well done, Christina, Olga. Very good, Olga. Yeah. Judgment. Good. Right. Now then. No particular difficulties there. Who'd like to read the next paragraph? Who'd like to kind of click the raise your hand button so I can see who'd like to speak next? Julia, that'd be great. Go ahead, Julia, you read, okay? Not too quick, you go ahead.
Okay. I have been with this firm for 20 years, and in that time, I have dealt with all aspects of employment law. This
Okay, no,
includes...
stop for a minute, Julia, stop for a minute. You've been with this firm for how many years?
Sorry?
How many years have you been with the firm?
12
years. Okay, good. Okay.
Oh.
Good pronunciation there. Just wrong word is okay.
Oh, sorry.
No, don't you worry. Please continue.
This includes drafting contracts of employment, advising employers on with new acts of parliament, health and at work issues, advising on all aspects of discrimination at work,
Good.
advising on family-related issues such as maternity and rights, advising on pension rights, protection, acting on behalf of clients at employment tribunals.
Okay, so it's tribunals. I know it looks as if it's tribunals, but it's tribunals. Just say tribunals.
Tribunals.
Good, very good. Right, everybody, let's see what the answers are. I've been dealing with this firm for 12 years, drafting contracts for employment, advising employers on right. In fact, it's okay now. Okay, I wonder how many of you are going to get this. This is not an easy one, okay? Advising employers, that very idiomatic legal phrase. I'm going to advise you on something with new acts of parliament. In other words, you're going to follow them. So excellent. You're going to comply with complying. Oh, wow, I thought that would be really difficult. Oh, great stuff. Okay, advising employers on complying with new acts of parliament, health and what at work issues. Health and, you hear it all the time in the US, in the UK. It's health and safety. When I was a child, there was no such thing as health and safety. You just got on with it. Oh, well, there we go. Right. Health and safety at work issues, advising on all aspects of discrimination at work. Discrimination means to unfairly target a particular person or section of the community. Discrimination, race discrimination, sex discrimination, religious discrimination, disability discrimination. What's this? Okay, right. And next, advising on family-related issues such as maternity and mater, the Latin word for mother, mater. And then the Latin word for the male version is paternity, mater and pater, okay? Paternity. Paternity rights, advising on pension rights, something protection. What protection would that be? Oh, yeah. What sort of protection would that be? Oops. Data protection. As you know, the European Union is has some of the most severe penalties for companies which breach data protection of their customers. As you probably know, under European legislation, if the entity, the company, the human being, is based in the European Union, then regardless of whether data protection takes place, maybe in Japan, maybe in South America, the European Union still has the power, it's given itself the power to still impose very severe penalties on the person or company that has breached the data protection. Right. Okay. Right. Okay, now one last volunteer. Anna, that would be great. Anna, thank you, Anna Smarakova. Would you
Yes,
read that for us? Not too quick, okay, but that'd be great. Go ahead, Anna.
It is fair to say that employment law has required an increasing number of lawyers over the last few years, largely because employees are a lot more aware of their rights than they used to be. Although there has been a lot of new, some of it from the European Union, so we have to keep employers completely up to date with the law. I think it's true to say that employers feel slightly underpaid at the moment. By that, I mean that employers feel they're being attacked by the law, while employees are protected by it. Employing people is a tricky business these days, and employers must get good advice every step of the way.
Very good. Just one word there, aware, the third line, a lot more aware.
Aware.
Yeah, as you know, it means basically to have knowledge of it. When we say, words like caution, careful, caveat, the Latin word meaning caution. Okay, so we say be wary means be careful. So an old-fashioned word for saying be careful, be wary of him. Something not right. Okay, so aware means to understand what is happening around you. You are conscious, your brain understands what is happening around you, you are aware. Okay, just say that for me, Anna, just say aware.
Aware.
Yeah, now unfortunately, when you're on the telephone, of course, I'm wearing a jacket and a shirt. And it sounds very much like I'm aware. So it's one of these words you have to be very. Make sure you stress the part. I'm aware. It's good. Otherwise, they think, oh, what's he wearing? What clothes is he using? Okay, good. So what goes in? Been a lot of new what? What has there been? There's a lot of it about. There's been a lot of what? Anybody? Oh, 6. And let's see any more. There's been a lot of new something. Legislation. Legislation. Okay, what's the spelling, everybody? Legislation. 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 Okay, good, everybody. Very good. All right. Now, let's just move on a tiny bit more. Good. We're going to have that as a home task. I gave you a home task. We're running out of time, though. Okay, I'll send the answers to the home task rather than go through it now. I'll send the answers to the home task in my email tomorrow morning. I want to move to contract law. A knowledge of contract law is important, not just for lawyers, just about for everybody. Anybody in business needs to know about contract law. Right, so we looked at how to form a contract. That's called contract formation with the 5 essential requirements. Now, one of the important things, it was the ancient Romans, basically, who, although we call it modern contract law, the idea that you'd have to pay if you broke a contract, breach a contract, it was formed by the Romans about 2,000 years ago. You'll hear it said in the English contract law, pacta sunt servanda. Pacta, pact, a bargain, in other words, contract. Sunt, well, must. Servanda, servant. In other words, must be obeyed, kept. Pacta sunt servanda, a bargain must be kept. The old Romans thought it was so bad if people entered into contracts and then broke them, that they actually imposed a penalty, a fine on people who broke contracts. This gave rise to the idea that if you breach a contract, break a contract, you're going to have to pay. Well, today you don't have to pay the state, but you have to pay the other party who suffered some sort of financial or economic loss as a result of your behavior. we call these different types of the money that you pay, or the different things that the court can order to put things right, are called remedies. There are lots of different types of damages which can be claimed as remedies. Sometimes you'll claim 2 or 3 of these different types in the same case. And there are lots of other orders, like an order for an injunction, just the other person is to stop doing something, or specific performance, that they must perform a specific act, like handing over the painting which they've painted. There are lots of different remedies. We're going to look at an introduction to contract remedies. Now, I'm going to send you this text for you to read as your home task, but I just want to deal with a few that's it, a few pieces of vocabulary. Now, and I really mean this. If it's great when you ask me questions, really great, because otherwise I'm lecturing to a computer screen. Not the most exciting thing in the world, okay? And because there's so many of you, I can't put your lovely faces on the screen for me to stare at when I'm teaching. So I'm just talking to the computer. So the more questions you ask, the better I like it. Okay, so what I'm going to do is I'm going to go through the words in bold black type just to explain their meaning. Then I'm going to send you this text to read with some home tasks. Right, so breaking a contract is called a breach of contract. The person who doesn't do this, the person who performs the contract, is the non-breaching party. The party that breaks the contract is the breaching party. Right. Now, the non-breaching party often suffers some sort of financial loss, so they want a remedy. They seek remedies. Usually, you ask for money, but there is also non-monetary relief. Court orders which are not money. In the Anglo-American legal system, again, a Latin word for money is pecuniary. If you have no money, you are said to be impecunious, meaning having no money. If you are pecunious, it means you have money. So pecuniary compensation means money compensation to the person who suffered the loss, which is the injured party. Fine. Now, the most common type of financial remedy is, of course, damages, not damage, but with an S, meaning money, damages. Now, the most common type of damages which are awarded or which are asked for and awarded are expectation damages, also known as benefit of the bargain damages. These are the amount of money which the injured party needs to put them back in the economic position they would have been in if the other party had performed the contract as they said they would. So if I say I'm going to deliver 10 cars to your car showroom for you to sell to the general public, and I know, we both know, you're going to make £2,000 profit on each car, and I don't deliver the cars, well, because I failed to do what I said, you can't make the £20,000 in profits that you would have made. So your expectation damages or benefit of the bargain damages will be £20,000. Right. Now, one of the big tests in the common law, especially for breach of contract, is you can only sue for losses which are reasonably foreseeable. Foreseeability means they're within the contemplation or within the mind, the ideas, the thoughts of the two parties when they made the contract. If something happens so incredibly fantastic that nobody could have foreseen it, then perhaps you won't be able to make a claim because it wasn't reasonably foreseeable. Now, all these types of damages I'm talking about, they're known as general damages. The damages the losses which flow from the actual breach of the contract. However, sometimes there are special circumstances whereby additional losses or additional failures to make a profit occur. in which case, whether or not you can make a claim depends upon the foreseeability rule, meaning, was it foreseeable by a reasonable person that this sort of loss would have occurred? We have also, in relation to the loss which occurs from the breach of the contract, or maybe some civil law claim for negligence because I'm driving my car badly and I injure somebody. These would be general damages they want. But quite apart from the damages of flowing from the actual breach, other losses may occur. Because I didn't supply the goods to your factory, you couldn't make the furniture to sell to the public, as a result of which 2 of your major customers cancelled their contracts. Now you're going to suffer an even bigger loss. That would be a special or consequential loss. Not merely loss of profits, but special, because it's not merely just flowing from the breach, it's something else. I injure somebody when I'm driving. I break their leg. This person has to stay at home for 2 weeks and has to employ a nurse to look after him or her. Well, the pain and suffering they suffer as a result of the accident is the general damages. I'll have to pay compensation for that. But because they need to employ a nurse, I'll have to pay the nurse's salary. That would be special or consequential damages. Not flowing, not as a result of the action of being careless and breaking their leg with my car, but flowing on from it, consequence of what happened, consequential damages. Now, sometimes people, let's say I say to you, I want you to paint my apartment, I'll pay you £1,000, and you start on Monday. Right, so you go out on Friday and you buy £300 worth of, £300 worth of paint and equipment. And then you arrive at my house on my apartment on Monday and I say, I've changed my mind. I've cancelled, I don't want to do it. Well, you haven't. Well, you've suffered an economic loss in that, in reliance on what I told you. You went out and you spent money buying equipment. You could sue me for reliance damages, where what is needed is the amount of money needed to compensate you for the expense you incurred in reasonable reliance that I was going to let you perform the contract. That's reliance damages. What you need is enough money to put you back in the position you were in before you entered into the contract. Before I said, you know, I'd pay you £1,000 and you went out and spent £300 on equipment. The position you were in is called the status quo. Status quo ante is Latin, of course. Status quo ante means the position you're in before you entered into the contract. Status quo ante. The position you're in after you entered the contract is called the status quo post. After. Right. Now, restitution damages. Right, this is a very complex area of law. This is where the breaching party is required to pay money to, because it received a benefit which it's not entitled to. I'll give you an example in a moment. So I'm going to, all right, let's say I take a cleaning job with somebody, right? I take a cleaning job and he pays me £1,000 in advance to go around to his apartment and clean it every day. And as part of my cleaning duties, I'm to look for all his unused drugs and to hide them. Well, that's a contract to commit a, it's a perfectly lawful contract to have a cleaning job, but it's not lawful to go around and hide evidence of his drug use or drug sales. So the contract can't come into existence. It is void. We say it's void ab initio. Right, but he's paid me £1,000, but there's no contract in place to show why I have received £1,000. That's what's called, sorry, I'm tired. That's, I'll tell you what the phrase is in a moment, okay. But basically, I have to restore him to the position he's in because there's no contract. I have to give him back his £1,000 because I haven't done any cleaning work. I've got to restore him, pay him back restitution, give up the money I obtained under the breach or void contract. Restitution also occurs where somebody completely fails to perform their consideration. Let me think. Right, you make t-shirts. I say I want 1,000 t-shirts with World Cup 2020 Qatar on the front. I know the t-shirts cost you $2 each to make. I know I'll be able to sell every t-shirt for $10. I agree with you that I'll pay you $2.50 to purchase, to make 1,000 of these shirts. You make them. I take them, I don't give you any money, and I sell every one of those 1,000 shirts for $10 each. I have totally failed to give you any consideration under the contract. I didn't give you anything. So you, in order to be restored to the position you're entitled now, in fact, to claim the entire amount of profit that I made $10,000 from selling those t-shirts. You can take all of those $10,000 as restitution damages. Right. Now, liquidated damages, well, these are very important in construction contracts. They're in America, they're called stipulated damages. Liquidated damages is the amount of damages are calculated, or a way of calculating the amount of damages is written into the contract before the contract begins. It's a genuine good faith attempt by the parties to estimate the likely loss to be suffered in the event of a particular breach, if it occurs, and that is the amount of money, that way of calculating the amount of money is used by the parties to compensate the innocent party, the non-breaching party, even if it's far more than the actual loss which the non-breaching party suffered. It can be very difficult. In the common law, it may be very easy to prove that contract's been breached, but it may be very difficult to actually prove what your economic loss is. And the common law courts are only allowed to award the amount of loss that you can prove you've lost. That's why liquidated damages are very useful sometimes. Liquidated damages clauses basically say, without having to prove the amount of my losses, this is the way in which we'll calculate the amount of money to pay me. It was a building contract. You're 100 days late in finishing this hotel. So you'll pay me $20,000 per day for the delay in completion. So you were 30 days late at $20,000 a day, at $600,000 liquidated damages, please. It's a shortcut to getting a verdict from the court, a judgment, which you can then enforce. As I say, it's known as liquidated damages in most of the common law countries. In America, they're known as stipulated damages or certain damages, what do we call it? Ascertained damages. It's ascertained damages in America by the court over and above any money claimed by the injured party. Sorry, I can see I'm breaking up. Punitive damages, punitive as in punishment, or exemplary damages. These are awarded sometimes in certain common law courts by the judge over and above any damages claimed to show the court's displeasure at the way in which the losing party has behaved. there might be some sort of tort, like racial prejudice, sexual harassment, quite apart from breaching the contract of employment. They didn't like this. Go to the rest of the world that they are not to behave like this. Extra damages are awarded by the court, known as punitive damages or exemplary damages, to punish or make an example of the person that's behaved in this way. These type of damages are usually only awarded where there's also been a tort. Tort is the law of civil wrongs, from the Latin word tortius, which means twisted, tortious. It's an old Norman French word as well, or it comes from the Latin, tort. The person who commits the tort is known as the, I like this because you've never seen it before probably. The party that commits the tort is known as the tortfeasor. This is the person who commits a tort. The tortfeasor. Very old Norman French, isn't it? Most people in England have no idea what that word means, but we have to use it, tortfeasor. Right. Now, one of the other remedies is to order to perform a specific act. For example, the builder who's building my house walks off the site. And I say, I don't want another builder to finish the house. I want that builder to finish the house. I don't want damages, money. I want him to finish the work. So I want an order for specific performance to perform a specific act, which is to finish building the house. Now, under the law of tort, right, 200 or 300 years ago, let's say 300 years ago, I enter into contract with Sir John. I say to Sir John, will you look after my castle for me while I'm away fighting with the king in France? Okay, and Sir John agrees. And then he doesn't look after my castle. He's broken our agreement. But I'm not going to sue him under contract law. I assumed that I was going to get a benefit from Sir John of him looking after my castle, and he hasn't. So under the old civil law of tort, he has in a way wronged me. I assumed I was going to get a benefit from him looking after my castle, and I haven't got it. So under the old tort law of assumpsit, let me write that, which is still mentioned in the US law sometimes. In that way, under the law of assumpsit, I've been wronged. So I'm not going to sue him under contract law, I'm going to sue him under tort law. Yeah, law of tort. There's only one remedy, and this is the remedy of rescission. To rescind a contract. To rescind a contract, rescission, means basically the parties are put in the position they were in before they entered into the contract. Money paid must be given back. Goods delivered, if they're still in existence, must be returned. You usually get more money if you sue under the law of contract for benefit of the bargain damages or expectation damages. Rescission just basically means you get your money back. That's nice, but it's not as good as getting that money I would have got for loss of profit. Default, well, default means somebody's failed to do something. You failed to pay your mortgage payment. It's a mortgage default. You failed to do what you said under the contract. You have defaulted in your duties. Yeah. Now, I'm going to be sending you as a home task, let's see if you've been paying attention, I suppose, this exercise 3, types of damages. I'm going to send you this text to read again, and then I'm going to send you this text about the different types of damages or remedies available under a contract. Yeah?
May I ask a question?
Sure, go ahead. Lisa, go ahead.
In Ukraine, we talk a lot about reparation damages. Are these only related to the war?
Well,
or there are other instances where this reparation damages could be?
Well, we talk about war reparations. After the First World War, the Allies sued Germany for war reparations, which I think is probably something similar to what you're talking about. Basically, the money required from the other party to make good, to repair the damage they caused, reparations. Yeah, but quite apart from, usually probably under the law of tort, let's say I damage your house negligently or intentionally. I've committed a tort. So you want money needed to put you back in the position you would have been for the damage. The damage. I've damaged your windows. I've damaged your door. You want reparations. That would probably be under the law of tort. Compensation to repair the damage. In a contract, however, we don't really sue for repair. We sue for all these different, we sue for these expectation damages or general damages. Yeah.
Okay, thank you.
Well, I'm not sure I really answered that, Lisa. I don't know. We talk about reparations, but they tend to be in relation to civil claims rather than contract law claims. Yeah.
Mm-hmm.
Okay.
I just wondered if they are used anywhere in the law apart from the money as a compensation for the damages caused by war.
We want reparations.
Mm-hmm.
Oh, I see what you mean. Yeah, reparations damage. Well, that's, war claims. I mean, obviously, Ukraine is going to have this vast $1 trillion reparation claim against Russia. Question of enforcement is another matter, but that's going to be, there's going to be a claim for war reparations. Okay. Right. Any other questions about contracts or contract law at the moment at this time? Right. Okay. So Olga is good. Olga, thank you. It's an interesting question. I saw these definitions in contracts: equitable relief, injunction relief. What is the difference? Right. Okay. I won't take too long. It's for 700 years probably, the law of equity has existed in the common law. Equity means fairness. Equity has lots of different meanings in the law, okay? But the law of equity means the law of fairness. Under the Earl of Oxford's case in 1627, so this court precedent is 400 years old, the King of England, the Chief Judge, King James I of England, who took over after Elizabeth I, he loved the sound of his own voice, but he loved a good discussion and argument as well. So he was the judge. Basically, somebody came and gave evidence on behalf of the Earl of Oxford to defend him against an accusation of murder of another courtier. The Earl of Oxford's a pretty powerful lord. The Earl is a pretty powerful post. The present Earl of Oxford is Michael Asquith, who used to live in Ukraine. His grandfather, the Earl of Asquith, was British Prime Minister for the First World War. Right. Anyway, a strict interpretation of the law would have meant that the Earl of Asquith would have been, the Earl of Oxford would have been convicted. Equity means fairness. So if a strict interpretation of the law would result in a very harsh result for a particular individual, then they can claim the shield of equity to say, even though the law says this, I claim equity, I claim fairness, because of my particular circumstances, the law is going to result in a much harsher judgment on me than it would on other people under the law, other citizens, other entities. And King James gave this that when the law, the conflict with principles of fairness, when the law and equity are in conflict, then equity will prevail. Equity wins out. Equity is a shield to protect people against extreme harsh interpretations of the law. Right. So every senior common law judge has the power under the law of equity to ignore what the law or the statute says and to give a judgment which is fair. Right. Injunction, an order to stop doing something, is an equitable order. Common law judges have the power to do this under the law of equity, to grant injunctions. Specific performance is another equitable remedy. Common law judges have the power to give, in a contract dispute, an order for specific performance, not under any statute, but under the law of equity. So injunctive relief is one of the different types of equitable relief. The two other types are specific performance and also what's called an account of profits. Right. So injunction relief is not different from equitable relief, it's just one of the types of equitable relief. Okay. Let me give you an example of equitable relief. A man is walking down the road out in the countryside and suddenly falls down with a heart attack. Very bad. The doctor's driving by. Doctor stops. The man is now unconscious. The doctor spends a lot of money and expensive medical equipment and injections and medicine, saving the man's life at the side of the road. He puts the man in his own car, drives him to the hospital, where he goes into the hospital with the man and then operates on him and saves his life. Now, the man is in a coma. There's no contract between them, is there? Can't be a contract. The man's in a coma. He's in no position to accept a contract. It's not quite fair, though, that the doctor doesn't get paid for all that time and expense. So we call this a quasi-contract. Under the law of equity, the judges could take the view that even though the man in a coma who's had his life saved hasn't entered into a contract, he would have if he had known what was going on and said, do you want me to save your life? Do you want me to spend $1,000 of expensive equipment and my time and saving your life? Or do you not want to enter into the contract? Well, of course, he'd enter into the contract. So the court could say that there's a quasi-contract, an equitable will proceed as if there had been a contract and will give a decision which allows the doctor to receive some benefit for the work they've done. So under the principle of quasi-contract, we're going to award the doctor £1,000 for the work they've done, even though there was no contract in existence. And we're going to do it under the law of equity to give a judgment that is fair, because otherwise the judgment is said, otherwise the doctor saved your life and lost money and you haven't paid him anything or paid her anything. That's not very fair, is it? So under the law of equity, we'll make an award under what is called its equitable relief. It's not an injunction this time, and it's not specific performance either. It's under the principle of what is called a quasi-contract. What was that in the text I saw in the last paragraph? It's a specific remedy. It's what we'd call, normally strong in contract law. Sorry, I'm tired. It's the law of it's yes, unjust enrichment. Sorry, I'm tired. It's unjust enrichment. Not that it's criminal. It's just, it's not fair that one person has received a benefit for which there was no contract in place to justify them receiving the benefit. So we call it unjust enrichment, in which case they must pay for the benefit they received. That would be an equitable remedy. Let me have a look at that question again. So an injunction relief, like specific performance relief, or an account of profits, which we'll look at when we come to intellectual property. It's a remedy under the law of equity, not the law of contract. Okay, everybody, we'll stop there for this evening. Sorry, I'm getting tired and I'm not making sense. Okay, sorry, everybody. Thank you very much for your time. I'll send you the recording tomorrow morning, together with this text, together with these questions, and then we'll go through the answers in our lesson on Wednesday.
Thank you very much.
Oh, thanks, everybody. Any questions? Any other questions? What's this? What's this? Any other questions? What do you got? I think you probably had enough of me, quite frankly. Thank you. Thank you, Chris. Thank you, Vika. Thank you very much, Olga.
Thank you, Richard. Thank you so much.
Thank you, Natalia. Okay, everybody, you have a lovely
Thank you.
week and weekend. And thanks, Olga. That's kind of you. Oh, more messages. What do we got here? Thank you, thank you, thank you, thank you. No, thank you, everybody. I'm glad you. I hope you enjoy them. I'm going to be in Oman by this time next week. I'll be in Oman. I'll be, let me see, it's 3 hours ahead there. So it's 6, it's 9 p.m. That's 11 p.m. It'll be a bit late in the evening. I might ask, who is it? Oh, yeah, I've got a potential new teacher. I might ask her to come in. What's the girl's name? She's from Brazil. Maybe in the morning her time. Okay, all right. Either I'll see you tomorrow next week, or it'll be Saraf, the barrister. Okay, everybody. Thanks very much for your time. Have a lovely week, or if you can, and I look forward to seeing everybody on Wednesday next week. Let's have a look at these messages in the chat box. Obrigada, boa noite. Thank you, Yushin. Thank you. Thank you. Have some rest. You're telling me, Olga. I'm looking forward to it. Okay. Obrigada, boa noite. Thank you very much. Thank you.
Obrigada, boa noite.
Thank you. Thank you very much, everybody. Okay. See you soon, everyone. Bye-bye. Bye-bye.
Thank you. Bye.
Bye-bye.
Thank you. Bye.
Natalia, thank you very much for joining the lesson at short notice. Yeah. Right. Thank you. Okay. Thank you, Lyubov. See you next week. Okay. Bye-bye, everyone.